This is a series of videos that I hope are helpful in reviewing the kind of notices the IRS sends out when they start collection action and what should be the proper responses to those. What does a levy mean? Well, a levy means they're going to take out what's in that account on the day they send it and the bank receives the levy. So that notice that will go out to the bank is a 668A, which should not be confused with a 668W. The 668A is a one-time levy, meaning it goes to your bank, and let's assume for discussion purposes you owe the IRS $50,000 for 3 years of back taxes, and you've not paid, and so the IRS sends that notice to the bank because they know you bank there. Well, what happens is the bank receives the 668 levy, and they hold whatever funds are in that account on the day they receive the levy, and they hold that for 21 days. If you had $100,000 in that account and you owe the IRS $50,000, they're going to pull out $50,000. They're not going to send it to the IRS, but you won't have access to it. You'll have access to the other $50,000. And at that point, it's up to you to contact the IRS and work out some arrangement that potentially could free up that levy, and you'd have access to that $50,000 that was captured. They're going to be very stingy about releasing any levies, because the levy itself is, one, designed to pay off the liability, but it's also designed to elicit response. And if the only way they can elicit response from you is to actually seize the money, then they're going to be stingy about releasing, because you ignored all the previous notices before, so you somewhat lose credibility when they actually take something, and then that means that you'll do something. So you want to definitely, if possible, respond before the IRS gets to levy action. Now, the 668A can be complicated. The banks know what to do with it. But if that 668A levy goes to, let's say, accounts receivable, they may not have seen that before, and it can often be confusing to the levy source, which would be a customer most likely. And obviously, receiving a levy that goes to the customer can be damaging to your business, because these are people that owe you money, and it may be an ongoing relationship that you have with them. And if they're receiving notices from the IRS, they are not to pay you but to pay them. One, it's something they probably don't want to deal with, nor do they may necessarily know what to do with it. Well, the 668 levy is, when it goes to accounts receivable, effective for anything that they legally owe you on the day the accounts receivable person receives the levy. So those funds will be sent off, but let's assume for a second you've completed work on a job and you're owed $50,000. Well, if you haven't sent the invoice, there's probably nothing that levy actually captured, because the customer hasn't been billed for it. Now, if the customer errs on the side of caution and later sends the funds to the IRS, well, you're kind of out of luck. The law really protects the levy source, and if they send it in error, well, you still owe the money. The IRS probably shouldn't have gotten the money, but you're going to be out of luck. So what's the moral of the story? If you're receiving levies, the levies are going to continue. So whether they've been captured in anything on the first time, you need to take action, because the IRS is going to continue sending levies and may move forward with more aggressive action, like a seizure, actual physical taking of property like your cars, vehicles, even your home.